Hello, everyone, and welcome back to the University. Today we have the next three hearings in the Raymond Davis trial in Nevada. We have 11/4/2019, where Mueller, who has returned to the stage, files a motion for bail for Raymond Davis. Then we have December 10th, 2019, which is a motion to disqualify Judge Bluth again. However, Mueller isn't able to be there because he's in trial in another area. So then we come back on December 17th, 2019, for the full motion to disqualify Judge Bluth. Let's see what the judge has to say about this. I'll be honest, I was a little surprised by Mueller and the things that he said. Let me know what you think in the comments. Hope you enjoy.
To Mr. Davis's matter. All right, that is page 15. Thank you. 15 is C-342-946, State of Nevada versus Raymond Tyrone Davis. He's present in custody. Mr. Mueller on his behalf, Ms. Collins on behalf of the state, has had the opportunity to review Mr. Mueller's motion, Ms. Collins' opposition. I'm happy to hear anything else. Mr. Mueller?
Thank you, Your Honor. Following up, based on the discussion and where I left off with things and where we're at now, I also met with Ms. Collins this morning to make sure I hadn't missed anything. Your Honor, I'm going to go ahead and ask the court to reinstate his bail. From my understanding that he had $25,000 bail. He voluntarily remanded himself into custody for a mental health evaluation. I asked that you go ahead and reinstate the bail. It was sufficient to make sure he came back to court, and it's been sufficient to make sure he stayed out of subsequent trouble. We're not going to ask for normal cognizance, just go, if we could get him back out of bail. He does have a business. It's not been shut for the last month or so, but if he can get back to it, he can continue to operate. He does have the same apartment he's now had for going on 10 years, 7, 8 years. I don't remember the exact number, but he's been there forever. So he was can be found easily, doesn't have any place else to go. So I'm going to ask for a $25,000 bail to be reinstated and set a trial date in order to question.
Ms. Collins?
Your Honor, I think I laid it out pretty well in my motion, but just for the record, I think things have changed drastically in this case since bail was set at $25,000. First and foremost, his criminal record, if you review page 6 of my motion, and I can lay it all out on the record if you like, that was not within the knowledge of whoever looked at the risk assessment. That was not broken down. Anything that was prior to 10 years ago was not laid out in that risk assessment. He has at least 3 prior felony convictions that I can find. He was arrested in Milwaukee in '86 for robbery, no disposition. Arrested in Pierce County, Washington for assault, obstruction of a public servant. He pled guilty to obstruction. 91, possession of stolen property ×3 plus forgery, found guilty of forgery, placed on probation. Arrested in Pierce County, possession with intent, guilty of the same, that was in 91, 92, guilty of attempt to elude a police officer. He was found guilty of that, was on probation. And I guess it's important to know that this time, that every time he was on probation in Washington State, he violated that probation. So he was brought back. In fact, one of his bench warrants that was outstanding was not quashed in 2017. I only suppose it was administratively quashed because they didn't extradite him. His criminal history continues. 94, assault in Washington County, Pierce County, Washington. Unknown disposition. He was arrested in Haywood, California in 2000 for acts with a child age specific, pursuant to California PC 288. That's similar to our lewdness statute. Ultimately pled guilty to delinquency with a minor and was placed on probation. Arrested in 2003 for trespass in California, 2004. The Las Vegas case that the court is well aware of, that was kidnapping and contributing to the delinquency of a minor. He was arrested in 2005 for threatening a crime with the intent to terrorize and kidnapping. There was no clear disposition of that case. He was also arrested in 2006 in California for violating TPI. So all of that criminal history was not known back when his bail was set at $25,000. I think what is also drastically changed in this case since the inception is this defendant's behavior and his willingness to manipulate the system, to manipulate this court, to manipulate the trial. His behavior during trial in 25 years, I've never seen it. I have never seen someone be so abusive to the process, to the court, to the prosecutor, to the court staff, to everyone in here, to go absolutely right up to the line and push this court for a mistrial till he got his way. And if you read in my motion, that was completely deliberate and calculated, because he gets on the phone as soon as he leaves court that day, and he calls his friend Terry, and he tells her, well, I knew I was going in today, so I took the dog wherever. I mean, that's how manipulative and, quite honestly, a little bit frightening to the state. If he's going to behave that way in a court of law, how is he going to behave now when he's out? I mean, his behavior has so drastically escalated through the course of this case. I mean, I have been called a racist. I have been called that I'm prosecuting him for some vindictive purpose, that I have mental health issues, that I am targeting him because he's African American. I mean, his version of the truth is just ludicrous at this point. It's just absolutely ludicrous, and the state thinks it makes him dangerous to the victims in this case, to the community. I mean, I can play a jail call for you from just yesterday, and the things that he believes are true, I don't think he's incompetent. I just think he is willing to go to whatever lengths necessary and say whatever he thinks is necessary to get out from under this case. I can play the call for you if you like.
So there's a few things, and I'm going to make my ruling today, but I.
Might be hurting or trying to produce.
Oh yeah, of course.
Certainly, Judge.
Of course.
Courts, and those of us who've done this for a long time, tend to be a little more emotionally detached. But every one of these cases has real emotions and energy tied up with them. That's the nature of the work. You can't survive in this work very long if you're not able to detach clinically and psychologically. You know that, Judge, you've done this. Now, what my colleague missed in her presentation, which would be a great sentencing argument, is that nothing's changed. He's been on trouble for about 15 years. I mean, it's not like it's been, you know, he's a businessman. You know, common law recognizes you go 10 years, you can't even ask about a felony. Now, he's got 15 years of generally, you know, trouble-free existence. He's in the same apartment, he's stable. The purpose of bail is not to punish. She may be unhappy with him, but the reality is the purpose of bail is to ensure his presence in court. I never heard her once in her argument mention failure to appear. Now, the purpose of the bail is to have him come back. 25 bail was sufficient to get him to come back. It's his money. I come back for $25,000. He came back for $25,000. It's fine. So respectfully, Judge, I believe my colleague might be missing the mark here a little bit. Not that everything she doesn't believe everything she's saying. That's not this issue. The issue is whether he's got enough bail to come back. He apparently, and I wasn't here, so I was in a weak spot when I wasn't there, but apparently both you guys were. He asked to be remanded into custody, did a competency evaluation. Now, that bespeaks, despite my colleague's skepticism, it bespeaks situational wherewit. It bespeaks the fact that maybe he's not competent, he wants to get checked out. Maybe he's not ready to deal with all the stress that gets involved in this. God forbid, I hope I'm never accused of a serious crime like this. I'm not sure how I'd handle it. Having said that, we're ready to defend him. Mr. Davis didn't have this problem with the legal system when Mr. Mader and I were able to run interference with him. I don't want to promise anything, but I think things will go a lot smoother from this point forward. And I believe my colleague might be a little more involved and look past the issue. Was the amount of bail posted sufficient to bring it back? It was.
I appreciate Mr. Mueller's commentary on what I've missed. He has 15 failures to appear in his history, and those cases remain in bench warrant. So I did speak to them.
All right, so here's the thing. Forgive me because I can't remember the case name. I want to say it's Washington, but I'm not 100% sure that came out this year in regards to, you know, making a change in bail. Cameron, okay, thank you. Making a change in bail, the court has to be presented with things that were different when the initial bail was set. So a couple of different things that I don't think the Justice Court was aware of when this happened is the defendant's use of 6 different names, 5 different date of births, and 6 different social security numbers. I don't think that there was any idea that the criminal history dated back to 1986, especially the violence offenses. But what's unfortunate, I think, for you, Mr. Mueller, is that the basis of the court's concerns were while you were not here, which is why I've tried sufficiently to lay a foundation for you, Mr. Maynard, to understand what happened during these 2 weeks. Because in all of the cases where I prosecuted crimes of homicide, crimes of sexual assault, never have I ever seen the display that I saw in this courtroom. The amount of patience I tried to exert because Mr. Davis was representing himself, the amount of times he continuously refused, absolutely refused to follow any request, any court order. He told the jury multiple times that he was forced to trial without an attorney. Over and over and over again, I told him not to say it again. He got up and said it right back again, even though he chose to fire you and Mr. Maynard and represent himself. He told me that he wouldn't be able to come back to court because his doctor had such grave concerns about the health of his foot, so I asked for a doctor's note. The doctor's note that he gave me said that he had light bruising and should take a Tylenol. He then told me that he wasn't coming back to court because he had a surgery on his foot on Monday. I kept thinking, why? He asked me every day, take this off, take this off, take this off. Why would he want that bracelet off so badly, but to leave? I even said, I will have someone take you, or would you please go down to house arrest? I'll have it moved to the other foot so you won't be in so much pain. No, I'm not going to do that. I'm not going to do that. It's either you play by his rules or you don't play, and that's not how the court system works. When his efforts weren't working, and I asked him, and I told him that I would not remand him for the house arrest bracelet issue, that I would not be taking that off. I apologize. It escalated to the point that he told me his mind was telling him to do very dangerous things, and he attempted to check himself into a mental hospital. Again, I asked for documentation. That documentation said that he needed to just go to therapy and that he was fine. When that didn't work, he tried dealing the case. This was what was most frustrating to me. He offered the district attorney $50,000. When she didn't accept that, he offered her $50,000, and he told her about a sex trafficking ring he has personal information about. That was if you know information about a sex trafficking ring where juveniles are involved, then guess what? Go to the cops. It's not part of the deal. It's about what it's doing right. His outburst where he screamed the F word at Miss Collins over and over and over again, to where my marshal had to get in the middle because he was afraid for her safety. But another thing that brings me a lot of concern is his break with what's really happening. The fact that he says he was forced to self-represent. He was forced into competency court because he wouldn't take a deal. That he's no longer allowed to cross-examine witnesses. His realm of reality is what he wants it to be. This doesn't have anything to do with him being black and someone else being white. He does not want to follow rules. And the fact that he told me that he was having issues with competency, and then later that afternoon called this Terry lady and told her, I knew this was going to happen, that's why I put the dog somewhere, it's all part of his master plan. That brings me absolute no comfort or solace in him being released from custody. I don't know if he will come back, because I don't understand why someone asked me to take off that bracelet so many times, and I gave him the opportunity to take it off and put it on a different foot, and he denied that right. His behavior has escalated so out of control that he has lost the ability to represent himself, and he has lost the assurances I had that he would come back to court. Most concerning of all is not only the community's safety, this prosecutor's safety, as well as the safety of the victims because of the way I saw him treat them on the stand. So the defendant's motion is denied. The state's request that the bail be set at $500,000 with house arrest and high-level monitoring is granted. I will also be issuing a written decision in regards to the factors of why this decision was made in the way it was, because I'm not comfortable with the representations that Mr. Davis makes in motions in regards to the court's rulings and why those were made.
I understand, Judge, and thank you. I appreciate the thorough analysis. Two things come to mind, and I will leave this, and then I'll leave the argument and set it for trial. The last 2 jury trials I've done was with a defendant who was very unpopular down in family court and did in fact have some, if not sufficient mental health issues disqualifying from proceedings, certainly made it hard for him to behave. I've been able to get that man into court, kept him calm, kept him through the process. I believe that with some assurance, with some confidence, that I think we can keep Mr. Davis under control. We had no problem with him in justice court. We were fine, even in my office. We didn't have any trouble with him.
Didn't he call the liar a fucking bitch? Or
What?
didn't he call the victim a lying fucking bitch in the middle of the prelim?
Yes,
That's what the transcript says.
page 16, yeah.
Yeah,
I
he
mean,
did, that's true. I
that's
touche.
one-
I didn't
I
recall
would
it.
count
He did have
that
an
one
outburst.
issue.
He did have an outburst, and I promptly calmed him down, and he did not have another outburst again. The other thing is, Judge, respectfully, would it be better if you transferred this to another department?
Absolutely not.
Well, all right, Judge, I understand the three of you guys have, now have, invested a couple weeks in the trial, but, it occurs that maybe the ends of justice would be better served if someone else looked at the case.
The defendant sought to recuse me twice. Both of those were denied. If you think that I should be recused, then I understand that, and I invite you to file the proper motion work so Judge Bell can hear it.
Thank you, Judge,
I know, I'm not taking
It's a very
offense.
frustrating line of work, and I'm not taking this personally, it just, from a detached point of view, it just thought occurred to me as I was listening.
I understand, and I don't take any offense, and if you think that's in the best interest of your client, then I am happy to pass that over to Judge Bell for determination.
All right, thank you, Judge.
Thank you.
Yeah, can we get a trial date in, I guess?
Yeah.
Mr. Mueller, if you would like to speak, then I would suggest you speak to Mr. Mueller, and then
I want to speak to the court.
No, Ray, done, no, you've said enough, more than enough. Okay, calendar call, Madam Clerk.
It's a February 3rd and February 10th jury trial. And it's a firm set, like we had talked about last time, Mr. Miller.
All right, thank you, Judge.
Thank you.
Alright, so Mr. Mueller is stuck in Las Vegas, so we're going to pass this until next Tuesday. State of Nevada versus Raymond Davis, C-342-946.
Good morning, Your Honor. Susie Collins on behalf of the state, 5391. I communicated with Mr. Mueller via text to see when he would be here, and I shared that text with your clerk. He is in an attempted murder prelim in North Las Vegas. They still have a witness left.
Yeah, so, unfortunately, Mr. Davis, since he's stuck in North Las Vegas, I'm going to have to continue this till next week. Thank you.
Your Honor, can I address the court?
Sir, I really don't think that's a good idea without your lawyer.
I've been pro per before. I know what I'm doing. I would like to address the court, please.
Your Honor, he's represented.
Doesn't matter. I can still ask
Well,
to address the court.
all right, sir.
Your Honor, District 6, I was in there Monday, October the 21st. I have the transcripts for here. I would like you to look at these transcripts. And I would also ask the court to get the audio and video. District 6 has altered and edited these transcripts. Once you get the video,
Okay,
once you get
sir,
the audio.
so if you have that kind of concern, Mr. Mueller needs to submit that along with as a supplement to the motion, okay?
Yes, Your Honor. Also, District Court, they are now not only in double jeopardy, they are in triple jeopardy. I would like to file some motions in open court.
Sir, I can't do that here. You are welcome to address that the next time that you're in the trial department. I am only here to view to make a decision on the motion to disqualify.
Okay.
So
Also,
I
Your
can't do
Honor,
anything substantive related to your case.
I don't know if you recall, I was in front of you in competency court. I actually wrote you a letter thanking you for, not only for me, but for other inmates of how you treated them. I think you're a very kind, very fair judge. On the other hand, Ms. Attorney Jacqueline Bluth is not. She has been prosecuting me from the bench from day one. They have broke every rule possible. They have stripped me of my constitutional right to represent myself. If I'm found competent, that means I am capable of representing myself. So why would I be stripped of my ability to represent myself in court? Greg Mueller has done very little. I have been rendered defenseless. She has falsified, D.A. Collins has falsified documents, given fake social security numbers, fake names to me, which is now in the hands of the FBI, and she has done everything in her power to keep me in jail.
Sir, so all I have in front of me today is the issue with Judge Booth, and I'm not going to make a decision on that until
Okay, yeah.
Mr. Mueller is here.
Thank you, Your Honor. I understand. I just wanted it on the record.
I will see you next week.
Thank you, Your Honor.
December 17th at 9 a.m.
Good morning, Your Honor. Speaking on behalf of Ms. Davis.
Good morning.
Mr. President, I proceed. Your Honor. Thank you. In custody.
Yeah, okay.
Anything represent the state?
Not necessarily.
Okay, no problem. Your Honor, I've been
It's a
practicing.
motion to disqualify, so.
Your Honor, I've been practicing law about, 30 years now, 30-something years. I think this is the first time I've made a formal motion to recuse a judge. I don't do this casually or lightly. Mr. Davis and I worked together through the preliminary hearing. He kind of got a little hot tempered at a moment or two, but for the most part, considering the nature of the allegations and the quality of the evidence, it's at least understandable. He then decided that he wanted to represent himself before Judge Booth. The proceedings apparently went relatively smoothly towards the end. Apparently, Mr. Davis then finally felt the stress of being in trial on serious charges and asked Judge Booth for a mental health evaluation. She then declared a mistrial, which as a matter of law I believe was wrong, but we'll sort that out at a later time, and then remanded him to custody so he could go get evaluated up at Lakes Crossing. He came back, and at request, I came back on as his attorney of record and set the matter for trial. I walked into court, and Judge Booth gave me about a 20-minute discussion on the bench about everything that Mr. Davis had done wrong regarding the trial. And at first I took it as, a casual discussion, as getting me caught up to speed, and it was helpful, got me up to speed quickly. Then the conversation went on quite a bit longer, to the point where it was obvious to me
I
that...
watched the jobs.
Okay.
Mr. Mueller.
All right, so you saw, it was pretty obvious to me that she's kind of emotionally invested in the case, and spontaneously it occurred to me that maybe she should just ask someone else to hear it and let Mr. Davis and I get to preparing the trial and finishing up. But the standard is, you know what the standard is, Judge.
Sure, so let me ask you a question though, because typically intrinsic bias, right? Any bias that a judge develops as a result of dealing with somebody during a case is not a basis for recusal.
No, it is not. But on the other hand, when it becomes clear that you cannot be fair and impartial, or that the appearance of fairness and impartiality can no longer be maintained, then the quality of the courts, the public's confidence in those courts is compromised. We're blessed now it's not like it used to be a long time ago when we had 10 or 12 judges. We've got 34, 35 judges, and all of which have trial calendars. And I believe that what I saw in court with Judge Booth made me uncomfortable. You've seen the jabs. Just based from your reaction a little bit, you had some concerns about it. I do not believe intrinsic biases.
I did not say that, Mr. Moore.
Well, that's true, Judge. I'm reading I'm presupposing. Having said that, intrinsic bias I don't believe is the correct analysis. More of a fairness and impartiality is the proper analysis to do this by. Now, and I want you to understand, this man was out of custody. No problems. Made all his court appearances, there wasn't a problem. Then we get a $500,000 bail. Now, that kind of bespeaks a sort of investment in the case that's, doesn't necessarily bespeak impartiality. He didn't pick up any new charges. The accusations here are already 5 or 6 years old and are made on behalf of people who's got, some serious credibility issues. Having said that, I don't want to argue the case. I believe Mr. Davis and any impartial observer would conclude that he's not going to get a fair hearing, even if the judge sincerely is trying to do so. And I believe that a reassignment and recusal and reassignment to another department would be appropriate.
All right, thank you, Mr. Miller. So I did watch the video, and I just didn't see what you're saying. I mean, Judge Bluth listed all of the issues that she had with Mr. Davis that led to the him being remanded. He raised a competency issue during the trial. She didn't ignore that. She took care of it. She sent him to competency, which frankly probably would have been easier to just keep going forward with the trial at that point, right?
I actually would have advocated that had I been in court. I actually would agree.
You know, I think judges have limited options when somebody is representing themselves and they're making that sort of assertion, right?
I would agree that that's an unusual thing to be presented with.
Yeah.
I won't
So,
deny that.
and so I didn't see anything other than Judge Bluth explaining all of the reasons she had made the decisions that she made. It was in the context of a, bail argument, and she also is denying any bias. I don't see anything that gives me concern that would be the basis of a motion to recuse. Certainly, she had some issues. I think anything that has presented itself would be in the category of intrinsic bias.
I would get the point where they would get, I understand it, just the last point, Judge, $500,000 bail. That kind of bespeaks more of an emotional involvement than, the guy's out of custody. There hasn't been any new accusations made any court appearances, and after this, you heard the whole diatribe, and she sets a $500,000 bail.
Wow.
Now,
I wouldn't describe it as a diatribe either, Mr. Mueller, but, I understand, and if you disagree with the bail decision, then that's not an issue for me, right?
No, strictly speaking, it's not. I'm using it as an involvement other than impartiality.
Well, I appreciate what you're saying, Mr. Mueller. Thank you. The motion is denied. Will court will prepare the order.
Thank you.
Matter to proceedings to compel Margaret Vasquez to appear as witness in the state of California.